Welcome to the 18th episode of the SCC Online Weekly Rewind, where we curate the most important and interesting stories to keep you abreast of the latest developments in the field of law. Hi, I'm Nilufer Bhateja, and in this week I have brought highlights of some recent significant updates of the Supreme Court, the High Courts, and some legislation updates. Let us begin with some news of the Supreme Court. Does merely residing in the same house make the in-laws an accomplice in a dowry death case? The Supreme Court answered this question and opined that the courts below had failed to consider the evidences that were available on the standard of beyond reasonable doubt. The bench stated that conviction of the appellants was not maintainable on a mere probability in the case of absence of direct evidence. The benefit of doubt ought to have been given to the appellants, the Supreme Court said. The Supreme Court, while dealing with the question relating to the maintainability of counter-claims in an arbitration proceedings, held that the Micro, Small and Medium Enterprises Development Act of 2006, being a special statute, will have an overriding effect in relation to the Arbitration and Conciliation Act of 1996, which is a general act. Hence, even if there is an agreement between the parties for resolution of disputes by arbitration, but if a seller is covered by the Micro, Small and Medium Enterprises Act, the seller can certainly approach the competent authority to make its claim. Further, if the counter-claim made by the buyer in the proceedings arising out of claims made by the seller is not allowed, it may lead to parallel proceedings before various fora. The court held where there is a provision for filing counter-claim and set-off, which is expressly inserted in Section 23 of the 1996 Act, there is no reason for curtailing the right of the respondent for making the counter-claim or set-off proceedings before the facilitation council. Dealing with the issue relating to the right of promotion under the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act of 1995, the bench of Judges Sanjay Kishan Kaul and R. Subhash Reddy has held that a person with disability should be considered for promotion along with other persons in the feeder cadre. The court explained that the mandate of Section 32 of the 1995 Act enjoins the government to identify the posts that can be filled with persons with disability. Thus, even posts in promotional cadre have to be identified for such persons and have to be reserved. The identification of such posts is no doubt a prerequisite for promotion for reservation of promotion for persons with disability. There cannot be a methodology used to defeat the reservation in promotion, the court said. A member of the LGBTQIA community approached the Madras High Court seeking police protection as she had apprehension of being subjected to honor killing. The court allowed her prayer in light of guidelines issued in the case of S. Sushma versus Commissioner of Police. The Gauhati High Court addressed a case wherein a woman was booked under various sections including Section 120B and 124 of Indian Penal Code and Section 2 of Prevention of Insult to National Honour Act of 1971 and had been in custody as she had used the Indian national flag as a tablecloth on the occasion of Eid festival. A picture of hers having lunch on the dining table with some guests went viral on social media. The court accepted the defense that the said incident was an unintentional mistake and asked the petitioner to exercise more care and caution in future and also directed for her release. While giving tribute to the hapless dog that had succumbed to acts of human cruelty, the Kerala High Court directed the registry to rename the petition as In Re Bruno, Suo Motu Interest Litigation the suo motu public interest litigation proceedings initiated by the High Court in the matter of executive and legislative inaction of the state government in the matter of protection of animal rights. The High Court took suo motu cognizance on noting that the instances of animal cruelty that were being reported. The court remarked that there were frighteningly frequent instances of cruelty to animals that were being reported in the media in the last couple of years, and that they believe that the state must now resort to some affirmative action to alleviate their misery. In the light of allegations of instigating and provoking local inhabitants against the team of COVID-19 vaccination drive and further diverting the general public from vaccination to other unnecessary issues, an FIR has been filed against this accused under sections 188, 269, 353 of Indian Penal Code. The district court, while observing that it is very unfortunate that while on one hand the government is making painstaking efforts to ensure the safety of the people against the deadly virus by such vaccination drive, the rumor mongers like the petitioner are acting as stumbling blocks in this lofty endeavour of the government. The court in this case denied anticipatory bail to the accused for obstructing the vaccination drive and for spreading rumours against it. In a very interesting decision, the SESTAT has addressed the issue of taxability of convenience fee which was charged by PVR Limited on its customers for online booking of movie tickets under the category of online information and database access retrieval system, which is defined under section 65 clause 75 of the Finance Act and taxable under section 65 clause 105 subclause ZH of the Finance Act. The tribunal referred to terms and conditions for purchase of a movie ticket and held that when a user accesses the website, he agrees to be bound by the terms and conditions. And further, the Commission observed that conjoint reading of the clauses of the terms and conditions of the contract would indicate that the purpose of charging that convenience fee is to receive a consideration for offering the facility of online booking. In a momentous ruling, the European Court of Human Rights has held that the victims of human trafficking cannot be punished wherein they were being prosecuted for criminal offences connected to their work in the cannabis factories as gardeners. The court remarked that it is well established that trafficking in human beings falls within the scope of Article 4 of the Convention, which prohibits slavery, servitude, and forced or compulsory labour. The court further laid down positive obligations under Article 4. Concluding its decision, the ECHR held that the state failed in its duty under Article 4 of the Convention to take operational measures to protect the victims of trafficking. New rules have been introduced by the International Financial Services Centres Authority for making regulations under the International Financial Services Authority. However, these regulations shall not be applicable to regulations made by the authority in respect of organizational matters. The Central Board of Direct Taxes has introduced a new rule for computation of short-term capital gains and written down value under Section 50 of the Income Tax Act, where depreciation on goodwill has been obtained. The Central Board of Indirect Taxes and Customs has waived off the penalty payable by any registered person under Section 125 of the Central Goods and Services Tax Act of 2017 for the non-compliance of previous notification between the period of December 1, 2020 to September 30th, 2021. The Minister of MSME and Road Transport and Highways has announced revised guidelines for MSMEs. The guidelines have included retail and wholesale trades as MSMEs and aims to benefit 2.5 crore retail and wholesale traders. Under the revised guidelines, the retail and wholesale trade will also get benefit of priority sector lending under the RBI guidelines. Thank you for watching. Stay tuned for more updates in next week's Weekly Rewind.